Hi, my name is Adriana Baez,
I'm Allison Small. Hi, I'm Aisha Chabamba.
Hi, I'm Kenzel Roney.
and we're here to discuss the event that transpired on January 29, 2019 at Gold Cross Health System. It has come to our attention that an employee did not comply with HIPAA regulations. Who's to say that there are other employees not doing the same thing? This brings us to review this matter in detail. Mrs. Jones, an administrator in the ER, noticed that an employee left their computer screen open with a patient's personal health information displayed for everyone to see. As if that wasn't bad enough, she decided to stay around to see if the employee would come back soon. And after 5 minutes, she went ahead and locked the employee's computer when she saw that the employee did not come back. This scenario puts us in a vulnerable position, as it could have been the Joint Commission who saw this violation. We come together as a group to decide what we should do to ensure that something like this does not happen again. As we all know, this is clearly a violation of HIPAA, as it is our duty to protect and keep patients' personal information confidential.
So, as some of you may or may not know, there are strong incentives for organizations to discuss voluntary statutory violations they have discovered on their own initiative. Some benefits of disclosing information will be healthcare organizations will be able to develop a more favorable, less adversarial relationship with their enforcement officials. The organization may have more influence over the conduct of the government investigation and the issues that are emphasized. There may be a reduced likelihood of subpoenas or search warrants being issued to the organization. The penalties assessed for a violation of the False Claims Act may be also reduced, and it's also less likely that the government will bring a formal prosecution in the first place. HIPAA violations can be penalized in proceedings instituted by the Department of Health and Human Services as well as the Attorney General of the states. Violations of HIPAA cannot be prosecuted by individuals, but depending on the jurisdiction, individuals can seek monetary awards based on loss of privacy, which can be anywhere from $100 to $50,000 per violation. Some of the common HIPAA violation citations would be employees disclosing information, like gossiping amongst each other while at work, like informing each other on, oh, Mary Sue is having her renal biopsy at 2 o'clock. Did you hear about that? Like, that's disclosing patient's information. You shouldn't be doing that. That's a violation. That's a serious violation. Medical record mishandling, if you have like patient's lab results on the printer at work and it's accessible for any and everyone to come by and take it and grab it, that's a violation right there. It's also another common form of mishandling records if you have like paper charts. Nowadays we're technology savvy, so we have electronic health records, which is a reason why we should lock our computers more often, but we know, especially in this case, that doesn't happen. Another thing is lost or stolen devices, theft of PHI, like desktops, smartphones, and other devices can be most vulnerable to the organization because if it's leaked out, if it gets in the wrong hands, then that's all of our patients' information leaked, and that puts us in a situation whereas we can't be trusted or we don't know what we're doing. We don't have the proper security laws in place. Another thing could be like texting a coworker about a patient's information. Again, that's not something that coincides with HIPAA. That's going against HIPAA. Posting things on social media. If you post like a picture of a patient that might be seen at a physician's office, that's a violation right there. It might seem harmless at the moment, but it could be detrimental later if it gets in the wrong hands. And one last thing is that employees like illegally assessing a patient's file when they shouldn't be, and it's not in their job description. Like if they want to check, oh, let me see how Miss Jones' surgery went, or let me see what time Miss Jones is coming in for her procedure, or let me see what Miss Jones had done that's not within your job scope, and that's not a part of HIPAA, that doesn't coincide with HIPAA. So those are some of the common citations that we see, or some of the common causes or cases that we see with HIPAA violation.
So also in a situation like this, there are many advantages in not disclosing this type of activity. For example, without self-disclosure, the enforcement authorities may never even discover the incident that took place. A minor event like this may become a much larger, a more serious, and a more expensive situation if disclosed to authorities. There's also a chance if enforcement authorities may view the incident as a more serious, they may view the incident as more serious than it appears and impose a much greater penalty than expected. In other words, it is possible for a small situation to get blown out of proportion. In addition to that, there is no guarantee that a prosecutor will be persuaded by the self-disclosure to forego bringing a criminal action against the organization. In some cases, non-self-disclosure will not only protect the organization, but it will also allow everyone as a team to work together in implementing a new policy that will secure our patients' medical information. It may not be necessary to damage the reputation of our organization. However, these type of decisions to whether to self-disclose or not to self-disclose suspicious activity going on in an organization is based off of a number of factors. Factors such as, does the incident involve actual illegal activity, or how exposed to prosecution are all of the members of the organization, or even how well do the facts fit within the lead and self-disclosure protocols.
So in conclusion, we have decided not to disclose this incident to the board, but we will implement a plan of action to resolve this issue. The process improvement plan includes a workshop with all employees, educating them that it's important to protect patients' information. We also highlighted the HIPAA law that was enacted to protect patients' information and gives them the right to choose who their information is disclosed to. We are all responsible of not disclosing patients' information without their authorization. Therefore, employees were trained on how to properly lock their devices, or how to properly maintain confidentiality by turning patients' information upside down when they're just laying around so other people does not have access to them. And if this process does not improve in 6 months, then we will start holding each employee accountable that are leaving their accounts open or are just leaving patients' information in plain view. These employees will be held accountable, and disciplinary action will take place against them. HIPAA privacy rule. Under the HIPAA privacy rule, healthcare providers are to protect and keep patient health information confidential. Therefore, as an organization, we want to make sure that we are doing everything possible to enforce this law
and provide high quality patient care and services, so we can continue having high HCAP scores, great patient surveys. We want to be recommended by other facilities and our own patients. We want our patients to feel safe and welcome, as if this is like their second home.
Right. So hopefully this would help us gain the trust of our patients and
and taking care of this internally would prevent this from happening again.
Thank you very much.
Good night.